Hi, everyone. Thanks so much for joining us here on Atlanta News First Plus. I'm Joy Lim Nakrin. I just wanted to share with you some of the top stories that we're following right now. Unfortunately, I have to start with a really sad story of a family grieving the loss of a loved one after a fire. Let me show you the scene here. This is in Lithonia. Really sad situation. DeKalb Fire Rescue got the call a little after 1 o'clock this morning, and they saw people outside this home on Huntington Circle. The home was engulfed in flames at that point, according to investigators, and residents told firefighters that someone was still inside. Well, that person apparently turned out to be a woman. The captain here says she lived in the home. There were a total of 5 people inside when the fire started. Only 4 got out safely, but again, that woman did not make it out alive.
When they were awoken by the smell of smoke, obviously, and subsequently saw fire as well, and attempted to locate the perished resident, and by that time it was too late.
So we know that 3 children and a man
You do whatever you
got
want.
out alive without any injuries, but again, that woman did not survive. The cause of this fire is still under investigation, and of course we're going to share with you any updates as we learn them, including what the relationship is of that female victim to the surviving man and children, whether she was a mom, grandmother, sister, something that we're working to find out. Also want to let you kind of know the latest on the Atlanta Medical Center. Several lawmakers hosting a press conference about its future today. You probably recall, if you've been following our reporting, that Atlanta Medical Center officially closed in August, and its closure leaves only one level 1 trauma center in the metro area. That would be Grady Memorial Hospital. So there's a press conference to be scheduled at 1 p.m., which we're going to bring you here live on Atlanta News First Plus, and of course we're going to bring you reports during our traditional broadcast on Atlanta News First as well, as we keep following the latest on this, because of course it impacts so many in the metro area. Also, we've been following the latest surrounding the new planned police training facility in DeKalb County for the Atlanta Police. And this is some video just from yesterday of some of the protests that were happening downtown and that we've been following as well. As you see the signs, as opponents call the site Cop City. They say stop Cop City. That's kind of what they're chanting. And it comes as nearly 24 people faced a judge yesterday after what police call an organized attack on that facility. My colleague Asia Wilson has a closer look.
I know it's crowded in there for y'all.
In the crowd, there were 23 people linked to the violence that erupted Sunday night on the grounds of the future Atlanta Public Safety Training Facility site.
Homemade shields. They had bags of rocks. They had fireworks. They had Molotov cocktails.
Each stood before the judge for a domestic terrorism charge.
That all the parties were involved via association.
At times, things got lengthy as statements were read for some defendants,
He's polite and treats others with respect.
along with multiple character witnesses, including teachers and parents.
I think the world of Tim.
The judge denied bond for nearly all of the defendants.
And obviously my concerns are the risk to persons or property in the community.
But then a legal observer with the Southern Poverty Law Center stood before the judge.
I can't stand here and say, like, a witness saw him throw something in particular, that we're not saying that there's not potentially a case against Mr. Juergens down the road. But at this stage, based on all of those things, we would consent to a bond.
He was given a $5,000 bond. We asked Attorney General Carr whether he will drop the charge. Carr said this:
Everybody will have their day in court.
as some would argue this type of proceeding is rare for a first appearance hearing in the state.
There are some judges in some courtrooms where this would have been absolutely nothing of the sort. It would have been perfunctory at best, and it would have simply been at no bond, no bond, no bond.
Legal expert Josh Schiffer said what was seen in the courtroom in this case on Tuesday was normal.
And it's common, especially in something that's got so much scrutiny on it.
All right, and joining us right now, we have criminal defense attorney Josh Schiffer here in our Atlanta News First studios, joining us to kind of flesh this out a little more. Thank you so much, Josh, for being with us.
Absolutely. Thank you so much for inviting me.
So, the first question I think that many of us in the newsroom had was kind of how unusual were the proceedings yesterday for a bond hearing? I mean, most of the time when we cover bond hearings, we don't hear from witness after witness after witness as each individual defendant is trying to get bond. Fair enough?
Yeah, I don't want to say it's unusual because each community kind of has its own process. What I think was most important was the clear effort by DeKalb County to bend over backward to make this as fair and transparent as possible. It's clear that the entire nation is looking at this particular incident. You can see that the people arrested were from all over the nation. This is a hot progressive topic. It was even featured in the New York Times this weekend. So DeKalb County had a distinct intent to show that everyone accused in this case is being afforded all of the opportunities to present their case. Normally in Georgia, in first appearance, it's pretty perfunctory. The judges have really limited powers into what they can do. They're allowed to grant a bond based on several evaluating factors because of the discretion of being a magistrate court judge, but that magistrate court judge position also prevents them from setting bond on more serious charges. Then you've got the fact that we have so many counties in this state, and each county runs their first appearance according to their county traditions, local rules, local flavor. DeKalb County runs a pretty active process. It's one of the largest communities in Georgia. So there's a lot of bodies that move through this process every day, and it would be rare that everybody would be afforded such a long period of time to present people like character witnesses, especially considering that this judge clearly was not going to be offering bonds to very many people. And I don't know whether that's because of a rule or whether they had some marching orders from upstairs. But given the gravity of these charges, a bond is arguably inappropriate. That combined with the factors the judge mentioned, specifically how far away so many of these protesters come from, that's the justification for denying them bond. And I expect that DeKalb County will continue being very transparent with the treatment of these accused as the case moves forward.
So you think it sounds like it was appropriate that the judge denied bond for most of the defendants, which is actually what happened. Like you said, I mean, the judge has to weigh whether the person is a flight risk, and because they don't have local ties, probably they would be, is what the assessment was. And then, like you said, the gravity of the circumstances, that this was what is being described as a violent protest, and so it has to be considered the potential danger to the community, its persons, and its property. More or less, correct?
Yeah, absolutely correct. In this case, I'm going to imagine officers filled out warrants on each and every one of these arrestees. And those warrants would be signed by a judge only after presentation of an affidavit for arrest that would include enough facts sufficient to prove probable cause, which is a very low legal bar. It's literally specific articulable facts. So once those officers presented specific articulable facts of the charges, the judge approved the warrants, they were arrested, and this first appearance is more about telling the accused where they are, what's happening, and informing them that the process has begun than anything else. If for minor charges, obviously, the court has an interest in moving people in and out of incarceration. But when you get to substantial charges that carry great weight and gravity, there's a real big interest for the state to not allow these people to bond out of jail quickly because the process needs time to be completed. Right now, what's happening is the basic investigation is going on, and these accused are filing for probable cause and commitment and bond hearings most of the time, which are going to be scheduled about 14 to 30 days from now. At the same time, the district attorney's office is also considering these warrants for indictment, which is the formal charging of a person of a felony in the state of Georgia. In order to do that, the case needs to be presented to the grand jury. It's a one-sided hearing, so it's not, there's not space for the defense, but in all likelihood, most grand juries return indictments At that point, the case would be sent from the magistrate court to the Superior Court of DeKalb County, and that permanent trial judge will be assigned. The accused are going to have an opportunity to ask for bond again during this pre-indictment period, but it's going to be up to that magistrate and the arguments that both the defense and state are going to bring forward as to whether bond is appropriate for these individuals. And as you mentioned, there are specific factors the court is instructed to consider when establishing or evaluating someone's appropriateness for bond. They're called the Ayala factors. And those factors include things such as ties to the community, the likelihood of committing an additional crime, their participation in the legal process, their prior record. And the judge did that assessment yesterday, clearly found that these individuals were not appropriate for bond, and we'll see them here sometime within 14 to 30 days for additional bond inquiries.
Okay, so that's part of what's next is additional bond inquiries. After that, what do we expect going forward in terms of the process?
I wouldn't be surprised, knowing DeKalb County, if they move efficiently with the actual indictments of the underlying cases, but that brings in a whole nother complication. Most of the time, the district attorney of the county is in charge and runs all of the criminal accusations in that county. That's why they were elected. That's the empowerment that we give them, the mandate that we give them by electing, is to choose how, what, where, why we prosecute cases. In these cases, by relying on the very specific domestic terrorism statute, it's allowed the state's Attorney General, Chris Carr, to enter into the case, and he actually has substantial authority, even though this is a county prosecution, to come in as the state attorney general and bring these charges. That's a specific part of this statute which was enacted in the aftermath of the horrific murders in Charleston at the church. And now this charge is, or this statute is being used to allow Chris Carr to come in and basically work with and work over the local assigned district attorneys and prosecutors in the handling of these specific domestic terrorism related cases.
So I want to ask you just about jurisdiction, because it is something that we've been talking about, and it's something that you've kind of alluded to here as well. You know, and I remember asking you before we came onto the stream as early as yesterday about it. There definitely seems to be some debate about whether Atlanta police and how they have the authority to make arrests there in DeKalb County at this new training facility, what is being called Cop City. We had some questions. Is it because they're deputized with the authority, or is it because Atlanta actually owns the property? How does that work?
There's some really complex nomenclature as well as complex laws governing who has authority and justification and where in the state of Georgia. So the city of Atlanta, which has the Atlanta Police Department, actually exists both in Fulton County and in DeKalb County. It also exists in Clayton County, where our airport is, and that airport is staffed by Atlanta Police Department officers. The Cop City land, or Wilani Forest, that is owned by the city of Atlanta. It's the former Atlanta prison farm, and it's about 300 acres connected to a bunch of other acreage, and it's known as being one of the largest undeveloped pieces of forest in a major metro area. So it's property of Atlanta, but it actually lies in DeKalb County. Then when you get the Attorney General involved, he brings his own law enforcement agencies, most specifically the Georgia Bureau of Investigation. So part of the defense of all of these accused is going to involve a thorough analysis of what officers were acting under what authority when arrests and investigations were taking place. There are absolutely laws specifically allowing crossing jurisdictional lines while continuing to have all of the benefits of post-certification police officers standards training certification. So Atlanta police officers don't lose all their police powers just by walking over certain lines or doing certain things, but there are arguments against that as well. Then we get into the idea of deputization, which is a sheriff's operation. The county sheriffs in Georgia, we operate under what's known as the strong sheriff system. The sheriff is the highest constitutional officer in any one county. And that goes back to the founding of the state and how we wanted to put local control at the top of our citizens' interests. So local sheriffs can deputize officers from other communities and civilians. That confers additional rights. So I'll be very interested in the analysis of what officer jurisdiction existed during these various operations. And it should also be noted for everyone, these agencies don't necessarily all get along. You have state agencies, county agencies, municipal agencies. It'll be very interesting to see how they interacted during this multi-agency investigatory project.
Josh, so you're a criminal defense attorney. That's your livelihood. That's your profession. I'm not sure if I'll have you disclose what your connection is to this case, if you don't mind.
So I was brought in early and worked for a number of individuals when they were initially arrested, but I've withdrawn from all of that representation. They've got permanent attorneys that have been assigned by one of the several non-governmental organizations who've gathered to obtain counsel. These are really serious cases, and each one of the defendants has the right to have independent and fair counsel. So it's going to be a big clog moving through the system in how to deal with these cases, and that's another big question considering how strained our judicial system is right now. Remember, DeKalb County's courthouse flooded during the snap a couple months ago, and it's still not back up to full operations, and the judges are working their rear ends off trying to move business as quickly as possible through virtual appearances. But still, our system is bursting at the edges.
Yeah. Sorry, just a little technical glitch I'm having there. But I want to ask you then, if you were their defense attorney still, what would be your argument?
Well, to argue for bond is a pretty straightforward effort because you're always going to be focusing on those Ayala factors. I imagine many of these people that have been arrested have limited criminal records, certainly in Georgia and quite possibly in their home state. So that's a really big plus. You want people to focus on their lack of prior criminal record. When it comes to some of the other factors, it gets more complex, but the court has tools that have been devised to assist the judges in ensuring the orderly dispensation of justice, and you've seen that with banishments. It is more and more common in the last 5 years, I'd say, to literally banish people from certain counties unless they are going to appear for work, health, or court. That is a very effective tool that is ancient in Georgia, and it's being used aggressively. Judges are basically allowed to kick you out of local jurisdictions and can pretty much kick you out of the state if they feel that that's an appropriate bond condition. And if I represented someone who was from out of state, I would use that as leverage to encourage their orderly release with the promise that they would not be coming back except to participate in the court system. The court is very interested in stopping their collaboration and are going to use the bonds accordingly.
Well, beyond actually the bond issue, though, what's your argument? I mean, if you've got one of these clients who's charged with domestic terrorism, what do you say?
Well, the overarching domestic terrorism statute is subject to judicial review, and these cases will be appealed to the Court of Appeals and the Supreme Court of Georgia in an effort to have them declared unconstitutional. And there's a variety of arguments as to why they might be unconstitutional. The kind of common sense one that I talk about is that depending on who was running the show, this law can be used to basically criminalize any social justice movement that has any kind of organization involved. That includes some of our absolute Georgia heroes, like the Reverend Martin Luther King Jr., and everybody that worked in the civil rights universe. This law is exactly what the traditional establishment powers during the civil rights struggle would have used to squash progressive social movements. There's a lot of worry about that. criminalizing and the over-criminalization of otherwise legal behavior is a dangerous line that a lot of civil libertarians, people on left, right, all parts of the spectrum are deeply concerned with, because at some point the people that run the show change. And when those people change, what was right and what was wrong flip upside down, and now everybody is subject to an overly aggressive prosecutorial possibilities.
Okay, and what about sort of, so it sounds like your plan of attack, if you're their criminal defense attorney, is really challenge the underlying basis of kind of for the domestic terrorism body of law in general, but in particular the acts of these particular defendants. Is there kind of an approach there?
I believe that there's going to need to be an investigation as to the acts specifically alleged. The officers detained 23 individuals over this last 72 hours. Those were 23 individuals out of a crowd estimated in the many hundreds, if not 1,000 or more. And there's video released of large crowds of people that were apparently or allegedly organized. And that's a key part of the domestic terrorism statute, is the organization, or the RICO statute that may also be brought in at some point. And there's questions as to why and how these 23 were selected for prosecution. There's also the possibility that others may be prosecuted, certainly if officers got the contact information for other people temporarily detained, and I understand there were many more temporary detentions. Those people could face warrants in the mail or a visit from a police officer as the investigation continues, because the state has the entire statute of limitations within which to bring charges. I think that there's going to be a review of more of the video evidence and additional charges coming. So to defend against that, if I was representing an individual, it would be concentrating on my individual's specific behavior and what evidence there was of my client's actions, as opposed to the actions of the rest of this crowd. There are people that were legitimately not being involved in violent and tumultuous acts, as much as there were people that were involved. And the state carries that unwaivable, unchangeable burden to prove you guilty beyond a reasonable doubt of your specific charge. And it'll be really interesting to see that. I also expect a deep electronic investigation into the communications that are involved in this group. The state benefits by labeling everyone, by corralling them into a defined group that assists them in their prosecution, and the evidence that they use to tie these people together, specifically appearing at places, surveillance, electronic communications, attacking those, recasting those, and examining those is a big part of getting away from domestic terrorism as a charge and returning to something more traditional, such as disorderly conduct or rioting or something that we're all used to.
Josh, in terms of the timeline, I mean, it takes a long time before, you know, from bond hearing to actual trial, right? When do you think we could expect a trial, and do you think that these defendants would be tried together?
I think that there's a lot of reasons for the state to keep all of these individuals together as co-defendants for efficiency's sake. Certainly having one judge unified over all of these connected cases, assuming the state can show that they are connected, is good for the efficient application of justice. When it comes to the timeline, though, that gets very complex. We're going to see those commitment hearings, bond hearings, probable cause hearings happen in the Magistrate Court of DeKalb County sometime within the next 14 to, I'd estimate, 30 or 45 days. That doesn't mean that the case is going to get indicted anytime soon. Quite possibly, DeKalb County will get the indictments done for those people still incarcerated within the 90-day rule. But that 90-day rule is being used much more as a suggestion than a requirement in many jurisdictions these days, and people are being forced to stay over the 90-day limit without an indictment. I don't think that's necessarily going to happen due to the profile of these charges. I expect that an indictment will flow in an orderly manner. The cases will be then randomly assigned on what's called the wheel to a sitting Superior Court judge, and the cases could be delivered to that judge as indicted well within that 90 days. then at that point, the judge determines where the cases would fall on that individual judge's caseload, and judges want to move things. But with so many co-defendants, that slows down everything, and it could literally be years before this case actually reached trial.
Wow. Incredible. So, I think we want to wrap up before we hit the noon hour because, of course, we've got our traditional broadcast, on television. But any final thoughts before we let you go?
I think this is going to be one of the defining stories of Georgia and what Georgia is and what Georgia's turning into. It hits on more levels. I could literally talk about it for hours. We have legislation affecting this with the DA and prosecutor supervision act that's currently pending in the legislature. We have dramatic issues of race and power and dynamics in Georgia, with this being a pro-police support initiative being Building Cop City. It's supported by some of the biggest charities and positive non-governmental organizations in the state, and we all agree we need this facility, but there are very strong and valid reasons to object to this particular development. Not just people involved in the police and criminal justice universe, but the environmentalists. There's a strong conservation argument because of the nature of this land. There are just so many layers in this case. I think it's going to be with us a long time. I think everybody that cares about Georgia is going to be caring about this case and paying attention to it closely.
Absolutely. I think you're 100% right about that. Well, thank you so much, criminal defense attorney Josh Schiffer. Obviously, you bring so much to this conversation, having worked directly on this case and representing, kind of the criminal defense side of it all as well. But it's something that we're going to continue to follow here on Atlanta News First Plus. Thank you so much, Josh.
Thank you.
And thanks to everyone for joining us. Have a great day.